The United Nations, an international organization founded in 1945. It is currently made up of 193 member states. Besides maintaining world peace and security, their job is also included on upholding the international law. Based on UN Charter Preamble itself, the objective is to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. International law comprises of a set of rules that govern the international relation between sovereign states and between individuals of different states. The Statute of the International Court of Justice, Article 38, had identified four sources of international law, which is treaties, international customs, general principles, and scholarly writings. Other sources includes the unilateral statements, the resolution and decisions of international organizations, and the last one is soft law. Treaty of Paris 1783. This treaty was signed in Paris by representatives of King George III of Great Britain and representatives of the United States of America. This treaty then ended the American Revolutionary War. The treaties and international customs have a complex relationship. They coexist, develop each other, and sometimes clash. Therefore, if there is a clash between an international customs and provision of a treaty, then, because they are of equal authority, whereupon being superior, it will prevail. The one that is identified as the lex specialis will prevail. The lex specialis will be determined contextually. In conclusion, international law have different functions. Among the function is to arrange for the cooperation most actors wish to have most of the time, to identify the membership of an international society of sovereign states, to regulate the competing interests of the various actors and to carry their agreements into the future, to empower weaker states as they press for change against the will of the powerful, to promote justice, and last one is to outlaw war.
Subjects of international law are entities in possession of legal personality. They enjoy rights and hold responsibilities towards the international community. International law replaced the medieval order of Europe by creating legal relations between entities claiming to be sovereign, equal and independent. As international personality is an inherent feature to statehood, states are the traditional and primary subjects of international law. However, there are other players, like international organizations, belligerent groups, multinational corporations, non-governmental organizations, and the individual. While they are objects of international law, yet enjoy a degree of international legal personality because states allow them to do so. International organizations are created by states. They are partial subjects, with limited rights and duties, as their legal personality depend on states' actions. On the other side, non-governmental organization is established by individuals, under domestic law, but despite the global reach and impact, it's not a subject of international law. While multinational corporations have extensive global power, sometimes even more than states, the development in investment law helped them to acquire a partial legal personality. In particular, as states and multinational companies are considered equal parties to a dispute before the courts. While international law is mostly made for states, the individual today is qualified as a partial subject of international law, in particular in the area of war atrocities, genocide, and crimes against humanity, seeing that these actions are committed by persons, and not by abstract entities. And lastly, when rebels or belligerents gain de facto control of a certain territory, they may enter into international agreement, which makes them a partial subject of international law.